Millions of people suffering. Millions of people having their fundamental right to life being infringed upon. Millions of people being exposed to unfair, brutal torture, being enslaved, being exposed to illegitimate police brutality, losing their family members. Exactly this sort of suffering is what these dictators of post-revolution states have been exposing their civilian population to. And exactly because of this crucial abuse of the most fundamental human rights we have in our society, we on side proposition believe that that the obligation to take action lies within the international community. And the problem we have identified with the status quo is that currently these brutal dictators are not being brought to justice and are not being properly prosecuted. We have seen this happen in the example of Pol Pot, who got house arrest, ladies and gentlemen, for killing 25% of the Cambodian population. This happened in the case of Ali Abdullah Saleh, who got immunity for cracking down on protesters during the 2011 Yemeni revolution. And this is due to the fact that post-revolution states still have the them versus us mentality so deeply in their society. They have a lack of security and so many other things they have to deal with. And for all these reasons, we on side proposition stand proud to propose the motion that this House believes that post-revolution states should delegate trials of former rulers and high-ranking officials to the International Criminal Court. Now, before we get into the substantive content of this debate, let's first of all clarify a few terms within this motion. We believe that post-revolution states, no thank you, in this case are states who've gone through a fundamental radical change within a short period of time, resulting in an overthrow of their former dictator. In this case, justice means implying a fair punishment within proportion to the severity of the crime, not too light and also not too heavy. And we are going to prove our case to you in the following 5 points. First of all, I will talk about the local failure of the post-revolution states. Then we'll talk about why the ICC is the right actor. No, thank you, sir. Third of all, why it's the obligation of the international community. And lastly, our second speaker will first of all talk about universal jurisdiction, and fifthly, the benefits of post-revolution states. So to dive into the substantive content of this debate, let's start with the first argument, the local failure. We see the problem that lies within post-revolution states is that there is a lack of objectiveness within the judicial system. And this leads to one of the 2 following scenarios. Because since the people who've overthrown the government are now in charge of the child, we have one of 2 following scenarios. First of all, the judicial system has not been replaced and is thus tied to the old regime. Yes, sir.
The ICC has spent $12 billion to successfully prosecute 2 people. What makes you think that they will be successful?
Because we see the ICC represents a neutral international body who has the expertise and has neutrality, but I will go on to that in my second argument more clearly. To come back to the first argument, we have the first scenario that the judicial system is tied to the old regime, either in terms of ideology or in terms of not having the legal knowledge required to prosecute cases of such severity. We saw this happen in the case of Pol Pot. This leads to the fact that they are biased towards the old regime and thus will not be able to fairly prosecute a trial. The second scenario is that we have a new judicial system that has been imposed by the rebels. And then this leads to the case of the new judicial system being biased against the old regime and being exposed to corruption for the old regime. This happened, for example, in the case of Mohammed Morsi in Egypt, where they prosecuted 600 of his supporters to death. And we see that this is a result of being biased against the old regime. No, thank you, sir. In either way, we see there's a lack of objectiveness and they cannot properly prosecute. Now, why should this referral to the ICC that we are proposing today be an automatic thing? Firstly, we believe that in the significant majority of cases, the post-revolution states are unstable and thus unable to deal with such complex cases. And even if we have cases where the post-revolution states would be capable, we see they are still unpredictable because they have gone through such crucial change in such short time. And with such severe cases, we do not want to take this risk, and we want to ensure equality between nations, that the people who should be brought to justice indeed will be brought to justice. So this brings me exactly to the second argument on why the ICC is the right actor, which will more detail, thank you, sir, answer your point of information. We have 3 levels of analysis. First of all, the expertise of the International Criminal Court. Second of all, their neutrality. And third of all, how they tackle the issues at the court. So to the first point, the expertise. We see classified as crimes against humanity, in certain contexts as war crimes, and also as genocide. And we see that these crimes are exactly what the International Criminal Court are created for. So since the International Criminal Court has this profile, the people who are working for the International Criminal Court have been specifically trained to deal with cases of such severity. So we see that they have the expertise like no other court in the world, since no other court has been specifically trained for that. And over the course of time, they will also gain more experience to deal with such cases. And this gives them a superiority to any local other court. So that gives them the expertise. Second of all, we believe that ICC has neutrality. They are neutral body, the least infamous court in the world. Now, why is this the case? They have internationally elected judges, which means they represent all different cultures from all different parts of the world. No, thank you. And most importantly, they're not directly related to the crime, which means they cannot judge it in an emotional way, but rather in a rational way, and thus bring these people to proper justice. Thirdly, we believe that the International Criminal Court tackles the issue at the core, meaning they focus on the real masterminds and the cause of certain issues. So there's no collective guilt or guilt by association. This means that the emphasis of the trial, and thank you sir, will be set correctly, and the right emphasis will be given by the International Criminal Court, as there will be no circumstantial affiliation with certain cases. So for these three reasons, we believe the ICC is the correct actor. Now to the third argument, the obligation of the international community. But first of all,
the ICC takes decades to prosecute individuals. How will societies move on your side?
because we believe, first of all, justice is required, proper justice, in order to move on, in order to give a basis for society to function on. But also, how are your local courts, or whatever you are proposing, how are they going to do this better? We believe local courts can also, in many cases, not get these dictators correctly. But now back to the obligation. They have infringed upon the most basic rights, such as the right to life, the right to not be tortured, and so on and so forth. And these are rights that are entitled to us for being human, ladies and gentlemen, not for living within the borders of a certain country. And so we believe that actually maintaining these rights, which form the basis of society, is within the interest of the entire international community. So we believe exactly for this reason, it is the obligation of the international community to take action because these fundamental rights that are entitled to us as humans have been infringed upon. Now, how does this tie to the International Criminal Court? We see the International Criminal Court is the criminal judicial representation of the international community. So in the cases that these fundamental human rights have been infringed upon, as they have in these post-revolution states, the obligation falls to the International Criminal Court since they are the official judicial representation of the international community. So, what have we on side proposition proven to you today? We have first of all proven to you that the post-revolution states themselves are greatly incapable in the vast majority of cases of dealing with these cases. And even if they are not, we see that we still must do it because they are unpredictable. Second of all, we have given to you multiple reasons on why the ICC is our body of choice. First of all, because of their expertise. Second of all, because of their neutrality. And third of all, because they are tackling the issue at the core and focusing on the masterminds. And third of all, we brought to you the obligation of the international community to defend these rights that are entitled to us as humans and not for living within borders of certain nations. And for all these reasons, we stand on to the
You know, we actually agree with bits of the last argument. Dictators can do horrible things, and the international community should do something. But that's precisely why we should not use the ICC, because the ICC is where politics begins and justice ends. See, the ICC is a court of last resort. Use the only local alternatives are completely unviable. Post-revolution, courts are perfect, but we think they are still often superior to the ICC and should not be abandoned. For three reasons in our side. ICC hurts closure and reconciliation. 2, because it denies defendants justice. And 3, my second speaker will tell you why it hurts long-term reconstruction. Our stance is simple. We reject using the ICC to trial former rulers and high-ranking officials. Instead, we support 2 main alternatives: holding trials in local courts or establishing truth and reconciliation committees in place of trials. Crucially, these are internal mechanisms that countries can choose. To be clear, we often support the local court in ways like funding, judicial advisory, or advice. We reject external authority and agency over the trial which they want to give to the ICC. We think this succeeded in Serbia, where the UN-funded Belgrade War Crimes Chamber successfully prosecuted former Yugoslavian paramilitaries. Now, before going on to my arguments, 2 points of rebuttal for their side. 1, on the bias, and 2, on the capacity of local courts. First, on the bias. They basically said there's still an us versus them mentality, and that means local courts will become biased. They never really explained this except give us 2 examples. So let's take them out. Yeah. Pol Pot. We say, in the actual instance of Pol Pot, the extraordinary chambers in Cambodia only started working, right, only after 10 years, after the ICC and the international community realized that they had to give authority back to local judges. And that's why in 1993, they gave authority back to local individuals instead. On the second example of Morsi, we say the problem was that, you're like taking over government, and the issue was a military coup which would happen even if the ICC were there. But more importantly, there's systemic reasons why Victor's justice and them versus us mentality will not be true. Why? Because a new government has no incentive to have an unfair trial. Several reasons. 1, because new governments need legitimacy in the eyes of the people. So there's every incentive to give a fair trial, because an unfair trial means they lose legitimacy. 2, because a new government wants stability in its country. It doesn't want more violence. So we say there's no incentive for them to have an unfair trial, which will therefore lead to more violence. So because a new government has no incentive for an unfair trial, we think very often they are not going to bring the judiciary, and that's why trials aren't going to be biased. Second argument they have about the capacity of local courts. Our first response is, okay, if your issue is that local courts might not have enough money or enough training, our policy already said we are more than happy to fund them, we are more than happy to offer advice. I give you the example of Serbia. This also happened with the Iraqi War Crimes Tribunal for the former members of the Ba'ath Party of Saddam Hussein. We don't see why this can't work. Instead, we see the ICC is in fact far worse. Right? The ICC takes forever to trial individuals. When they tell us that ICC judges are elected by different nations, you know what this really means? It means that nations horse trade between themselves. They don't really care whether the best judge goes to the ICC, but say, okay, we'll elect your judge to the ICC if you're willing to give us this policy concession somewhere else. So very often the judges on the ICC are not competent at all, no thank you. And that's why ICC prosecutions, you know what? Only 2 of them have succeeded in 12 years and $12 billion. That's not a very successful policy to me. No. And that's why when they tell us proper justice takes time, times when people are denied closure. Because people are trialed for such a long time that it passed that former dictators die before they actually got convicted. We don't think that's justice in any meaningful sense. No. Moving on therefore to my first argument. Why ICC trials of closure and reconciliation? Because they aren't trusted by the law. See, the ICC is accountable to international and not local standards. Moreover, these judges are perceived to advance Western interests because they answer to the assembly of state parties, which is dominated by Western powers like France and the UK. Before I move on, yes.
No, the ICC is not dominated by Western powers. In fact, the biggest bloc in the ICC is by African countries.
Yes. Actually, that's not true, right? The African Union in 2012 under Kenya already said they reject the ICC because it was indicting too many Africans. It is perceived as a Western power, and that is why the African Union rejected it and said it would have nothing to do with it. That's why Omar al-Bashir can fly around all the African states and not be caught, even though there's an ICC warrant for him. That's why even non-Westerners, like Botswana Vice President of the ICC, Masebono Munadi, are pilloried as Western puppets who have betrayed their local roots. We say therefore, many post-revolution states and their people deeply mistrust the ICC. This comes from one, they refuse to testify at the ICC. In the ICC's trial of Sarah and Kenyatta, half the registered witnesses pulled out, forcing adjournments for evidence and some charges to be dropped. Such trials deny closure because they wait years for a verdict that never arrives. That's why we told you the ICC has been so inefficient in the past 12 years. Second, competing factions often refuse to accept ICC rulings by accusing each other of being in league with the West. See, after the ICC trial of Kenyan Vice President William Ruto, Ruto's Contention tribe and the opposing Kikuyu tribe both accused each other of manipulating court proceedings without Western collaboration. leading to violent riots in Nairobi. How is our side better? First, because local courts are staffed by local judges upholding local law. And the local citizens, you see, they're much more likely to testify and follow the rulings of these courts when they believe in their integrity. And second, because even don't use local courts, truth and reconciliation committees often remove themselves for the source of conflict, because they don't pass absolute judgments on who was right and who was wrong. Instead of obsessing over blame and guilt, they encourage constant fact-finding to mend societal rifts, and this is often much better for reconciliation. So the ICC trial damaged reconciliation, and they denied closure. Second argument, that they deny justice to defendants. See, applying the law justly requires the nuanced understanding of context. And here the ICC is massively disadvantaged in two ways. One, many actions the ICC considers crimes might not actually be crimes, or crimes of the same severity. For example, using child soldiers is abhorrent to us. Well, that's because the West arbitrarily mythologizes 18 as when children become adults. In many non-Western cultures, childhood is viewed differently. Right? In tribes like the Sharia and the Maasai, turning 12 marks the transition to adulthood. You gain the right to marry, to own property, to make decisions for the tribe. You are functionally an adult. In this culture, this is not a crime, and we don't think leaders should be punished for it. See, local courts understand these concepts and thus don't prosecute such trials. For example, a Congolese district court dropped charges of recruiting child soldiers against Commander Mabenga after it was revealed that he only recruited volunteers. Second, local judges are fully immersed in the context of a society, and this means they better interpret seemingly disparate pieces of evidence in a holistic manner. For instance, whether a general is guilty of genocide isn't just asking, did he order that attack? It's whether his words implied that order, or whether other attacks were separate acts of ethnic violence or part of a broader directed pattern of ethnic cleansing ordered by this general. You see, this requires intimate knowledge of the local language, customs, how different groups will interact with each other. And the ICC can call all the experts at once, many of whom won't even turn up. But you see, that judges will never have the holistic understanding of local society that local judges have, making them far worse at interpreting evidence. So, say local courts better decide which actions to prosecute and better interpret evidence when prosecuting crimes. I think the ICC denies individuals justice. It damages reconciliation, and we say that it denies victims the closure they so desperately need. I'm very proud to stand in opposition.
Genocide, war crimes, crimes against humanity, horrible things that we seem to all agree on are horrible. And the question is, how are we going to solve it? How are we going to bring the people who actually commit these crimes to justice? Instead, opposition comes up here with this great solution. We got local courts who are going to solve it, and we got truth and reconciliation committees who are so great and are going to bring peace to everybody. Furthermore, they tried to criticize us on everything we brought on analysis to the ICC. So before I get into the aspects of universal jurisdiction, how we're going to create global checks and balances, and furthermore, how we actually benefit from post-revolutionary states themselves, let's go step by step through what we heard so far. So first of all, they proposed the idea that local courts can do it, and that we have truth and reconciliation committees. First of all, they ignored its entire first speech, giving you the analysis on why local courts can't do it. They are a post-revolutionary state in upheaval, trying to set up a new constitution, a new government. People, clash of ideologies, people actually in upheaval, emotional, not able to deal with this at the moment. The courts not being systematically organized, having to implement a new judicial system. No, thank you. Them being biased. They simply said that no government would ever have an incentive to be biased against the old rulers. How does that make any sense in any world whatsoever? We point to the example that Eli brought to you of Egypt, where, for example, after Morsi was taken out of power, the new judicial system just did terror by mass punishment by prosecuting 600 people for no apparent reason. How is your point still standing that no government will ever have the incentive to not be biased towards the old regime? Because we see that people are emotional, information, not deal with this, because their families are affected by this, and they are never going to be simply accepting that a ruler that we not to put like the appropriate, in their opinion, punishment on them. Furthermore, they talked about how well local courts, we could build them up everywhere like we did in Yugoslavia. Okay, wait. Let's realize what crimes we're talking about. No, thank you. We're talking about war crimes. Crimes against humanity and genocide. Those are crimes that happen maybe once in a lifetime in a country. So what are you going to do? Set up crimes in every single country where that happens just to have the court disappear again afterwards? No, thank you. We think a proposal to have one international body to deal with this all over the world is a lot smarter and a lot more efficient and will cost a lot less money than if you have a court in every single country trying to deal with this significant amount of terror that we see happening here. And they try to attack us on the point that the ICC takes too long, that 12 years, that they're not getting anything done, right? Well, first of all, we point to the fact that it's not the fault of the ICC itself, that it's oftentimes that they flee into other countries that are not part of the ICC yet, and they are not able to extradite them, no thank you. But furthermore, we point to the fact that the ICC has only been in place for 10 years. Realize this, 10 years. After the United Nations was in place for 10 years, there were 60 member states. The ICC has been in place for 10 years. We have 122 member states. We don't see how this point still stands that the ICC is not getting anything done. Like, we have this push for international jurisdiction, which all countries are agreeing on, no thank you. Then they came to us with this point of, well, how the judges are biased and how everybody's against Africa and so on, and how Africa actually doesn't really want to do this, right? Well, we raised a POI from Olivia which said that Africa, in fact, represents the biggest regional bloc in the ICC with 33 countries. They brought to you the idea that the African Union actually opposes this, and this satisfies this. Well, then we asked you, the African court set up by the African Union actually has less member states than the ICC from Africa. Yes, please.
So you tell us that people like Omar al-Bashir flee to other countries, so it's not the ICC. You also tell us that these other African countries actually really love the ICC and cooperate with it. How does this make sense?
Because 7 cases that are trialed at the moment, 4 of them were specifically delegated from the African countries, 2 of them by the Security Council, and only 1 of them by the incentive from the ICC. So we actually see that the African countries themselves see the necessity of the ICC and see how they actually want them to deal with this because they see the expertise that Ellie pointed out to you in her first speech. Then they went on about how we're not going to bring peace and reconciliation because, well, the witnesses aren't going to trial in front of the ICC. Evidence proves you wrong because we actually see that for every trial the ICC has conducted so far, there have been hundreds of willing people to testify also against the 12, 13, 14-year-olds and actually went to the ICC and testified. So we don't see how that stands because we do see that the people have the incentive to actually gain closure and so on. And then they came up with this really strange idea that we shouldn't prosecute when child are recruited before the age of 18 because some cultures don't do that and we need to respect that. Well, first of all, then why did the African court or the African countries actually agree to be part of the ICC? If they would disagree with this, like we don't get that point. Because we see that it is universal understanding that in the modern time that kids should not be soldiers, and that there's a really ludicrous point coming up from that opposition. Furthermore, we point to the fact that, for example, genocide, one of the main things that the countries that the ICC deal with, is a crime in every single country in the world. Okay, so let's move on. We're talking about the universal jurisdiction and how we actually believe that we can create global checks and balances. Because what we see is that the ICC can defend our moral values a lot better than local courts and so on. Because what we see is that either the countries themselves delegate the child, or maybe they don't, but we have the incentive to do so because we as the international community actually otherwise would have a loss of our values. But I'll go into that in a moment. Yes, please.
The ICC currently has over 40 pending cases in the prosecutor's door. Tell us why it will be any more efficient in your world.
Because the ICC is dealing with them. We have the 40 cases. Like, we don't see how you are going to deal with them any better. What we see is that the ICC is actually taking action and so on. But let's move on, because what we see is that we have actually, through international law, we see ourselves also morally bound. Because what is actually the impact of the ICC? Because we see that it is holding people accountable. It is creating global checks and balances by creating a universal jurisdiction system. Because what happens when we actually have the ICC functioning and moving on in future years? What we see is that people, that former rulers would know that if they do something wrong, they will be prosecuted. that if they do something wrong, they cannot simply get away with it. They have to suffer the consequences for their actions. The ICC is not just regionally bound like local courts. That we see that if people just flee from one country and the local courts were to take care of it, we wouldn't get anywhere. The ICC, through their international or through their transnational jurisdiction, actually has the ability to also hold people accountable when they flee the country that they were in. So what we see is that people cannot simply conduct any kind of crime without just simply getting away with it. And this is a deterrent for people that they know if they do something wrong, we hold them accountable. But what we also see is that our fifth argument, the benefits towards the post-revolutionary state. Because as we painted the picture, they are in upheaval and they are unsafe. So what we create is actually safety, not only for the people itself in the country, because we redirect the anger out of the country by taking the emotions out of the country, by putting it towards the ICC, that if the people aren't happy with the jurisdiction, that they will actually not be mad at the local court, at the local government, but at the ICC. And we're fine with that, because if they're angry at the ICC, then they won't take their anger out on the local government. They won't create more riots, they won't create more upheaval, and there will be more safety, and there will be more chance for us moving forward in a stable new government. So what we've shown you today is that we furthermore, in addition to what Ellie said, we create global checks and balances. We hold people accountable, that you cannot get away with anything you do, that we as the international community actually stand for global values, that we stand for moral values, and that we also want to benefit the post-revolutionary states by redirecting anger out of the local states at the ICC, and thus creating new stable governments. So for all these reasons, we beg you to propose. Thank you.
Egypt, Chad, Qatar, and the UAE all refused to indict and arrest trial of former rulers and high-ranking officials is especially important because the scope of crimes committed by entire government is likely to be comprehensive. This means that we establish a rich volume of legal precedents by formulating legal principles to interpret the law in the long run. For instance, the trial of former Czech dictator Hussein Herba by the extraordinary African chambers in Senegal set the precedent for prosecuted cross-border atrocities. It also provided the impetus for open trials accessible to victims and NGOs. Here is where my material further clashes with what the second speaker brought up. The first idea was that of deterrence. We think it's a silly argument. If that argument were true, then the ICC, by prosecuting Charles Taylor and Thomas Lubanga, would see no more further prosecutions because everyone would live in fear that the ICC will come after them. Secondly, about safety. This too is a ridiculous point because the ICC actually has no witness protection scheme. In fact, its witness protection schemes are contracted and outsourced to local courts, to national courts. So by their own metric, the very safety they talk about comes from within the country and not externally. But the second tier of my argument is that the ICC is governed by jurisdictional, not definitional statutes. What exactly does this mean? This means documents like the Geneva Convention and Rome Statute grant huge leeway for judges to interpret statutes rather than apply by unambiguous definitions. For instance, the Geneva Convention does not define who the status of a legitimate combatant applies to. Judge Shireen Fisher considers a legitimate combatant to be any soldier who does not willfully attack civilians. But Judge Emmanuel Adelé applies stricter standard where a legitimate combatant excludes even soldiers who have unintentionally caused collateral damage. Therefore, the ICC will be seen as inconsistent on their side. On our side, local courts are better because they are governed by local laws which are narrower in scope since they only apply locally. Therefore, they don't need to be phrased vaguely to apply globally and to be all-encompassing. Therefore, local laws provide upholding local law, right? So everybody then will have this reconciliation. Now, we brought our point of redirection of anger, which was very briefly addressed by the second speaker, and we say that actually, if we still have these two very separate parties in a post-revolutionary state. You have two very distinct groups. And so what happens is that if the judicial system rules either way, the people can actually start clashing once again, and that is actually very counterproductive for the whole reconciliation that is the goal of both sides today. Now, lastly, they also said that the locals are very fully immersed in the conflict, and that's the problem we see, because if they're very emotional attached to it, the policy sees that they will be biased, unconsciously, and we now cite opposition to actually prove that point wrong. Lastly, they also talked about how the power-hungry government needs stability, and that comes into the goal of today. We say that yes, we want to bring stability, and exactly by going with a set proposition, you redirect this anger so that people can actually have reconciliation. Lastly, I asked the POI, how exactly will those judges be neutral if the judges were so attached to it? All she said is that judges are the most neutral people in the world. Ladies and gentlemen, corruption exists, not all judges are neutral, and we hope that you are, but we say that in fact, just saying that all judges will be neutral is complete crap. Sorry. So moving on to the next section, we'll talk about the ICC. So really we said that the ICC is the right actor, right? Because that fits their profile and they go right after these grants, the judges are specifically elected from lists by the Assembly of State Parties, and they have specifically trained to deal with international crimes and crimes against humanity. Now, we see that because of the expertise, they have this superiority in knowledge, right? And they can rule better. We also talked about their neutrality, how they're chosen from all over the world, and that therefore grants very different perspectives, but also that they don't have this link to the conflict, which might have made them riot in 1 second. And lastly, we say that they only deal with the core, the masterminds, and I'm going to go on to that after the POI.
So your entire case is predicated on locals trusting and liking the ICC. But then you say, we'll redirect anger at the ICC. Does that mean they'll never cooperate and testify and follow the ICC?
Sir, we believe that in fact the people will testify because those were the people that suffered. We believe that the people will indeed testify so that the ICC can bring them justice. What those people want is reconciliation. And if the outside party comes and offers them that, then we believe that we will have this cooperation. And as our second speaker has already granted you an example, hundreds and hundreds of witnesses come. Hundreds and hundreds of witnesses have witness protection. They have witness influence too, so that they can do something. And therefore we believe that point doesn't stand anything. Now, lastly, talking about the ICC, right? We said that they only attack the mastermind. And why is that important? Because it grants neutrality and it puts emphasis into the ICC. It focuses their trial. Now, she also said that they don't trial everyone, and this is exactly why we propose. Now, she said also that the countries don't in fact catch these people, right? And many times they can't catch these people. But we believe that it's actually more probable that they can catch these people if you have an international court that has no boundaries, that has no frontiers. Lastly, she said that delegating is unfair because these trials are so important for the country, and the judicial system has to be trusted. This is exactly what I just addressed. Because the judicial system has to be trusted is exactly why they should not rule. Because if they do, half the population will in fact not considered unjust. And if they are not considered just, they won't be credible, and the people will start clashing all over again. No stability, no goal inside opposition of the House. Now, all they brought against the ICC was no principle. All they said, they take forever, they waste a lot of money, and then she comes up and she says, hey, we can fund more local courts. If we can fund more local courts, we also believe we can fund more the ICC. But not only that, they say they talked about how we should not meddle with the judicial system, and we say how is that not meddling with the judicial system? But what believe that because the ICC is fair, neutral, because the ICC indeed takes these cases and cares about them because they have the expertise, because local courts are useless when it comes to this, and because of the fact that the ICC is the right actor, is legitimate, and is the duty of the international community, we still say that this abuse has to be taken care of and has to be taken care of by us. Thank you.
Proposition tells us that the principle of international obligations are important. We have consistently argued down the line that the ICC as an institution doesn't fulfill them and therefore doesn't uphold that principle. We uphold this principle better because we have proven that local alternatives are good. Remember, just saying that a crime is of global concern doesn't logically include the link that the ICC as a body should prosecute it. This is no contradiction. Let's make it very clear before I delve into the three areas that I'm going to talk about. One, I will tell you about our principle of justice. Two, I will tell you about our principle of closure. And third, I will tell you about our principle of post-conflict resolution. First, on our principle of justice, I'd like to point out that many former dictators and high-ranking officials don't commit crimes that strictly fall under ICC jurisdiction in the status quo. Notice how proposition only talk about war crimes and crimes against humanity, ignoring say lots of high-ranking officials in many post-revolution states that may not fall under this ambit. No clear policy from their team. No thank you. More importantly, we heard local courts are bad for justice because either the judiciary is biased against the new government or is biased toward the new government. First, this commits the fallacy of the excluded middle. It's precisely because judges of varying affiliations exist on both sides that a fair judiciary can be constructed in theory. But here's the question. Instead of asserting to me that there will be bias, we have to ask what are the incentives of the new state that comes into power. And we think such new post-revolution governments need stability. They don't want the perception of a sham trial because it will delegitimize their movement as a whole. They want international aid. They don't want to be seen to be having kangaroo courts where former leaders are just dragged up and prosecuted in the space of 5 days. No, thank you. Third, we have argued that not all revolutions are driven by power-grabbing opportunism. Lots of such revolutions are driven by a genuine desire to see things like democracy, to see things like liberalism. That's why we have like the Arab Spring. In the first place, we argue that that's not the incentive of a new post-revolution state. The only response we heard was Egypt and post-revolution Morsi. First, I'd like to point out that this was a military coup, not a revolution. Definitionally, this example is already tangential. Furthermore, we argue that local courts would still have been better because the ICC would further inflame the kind of sectarian tensions we saw in these countries. Next, we heard local courts are bogged down by the mayhem of the revolutionary process. First, you are conflating issues. A court that decides on constitutionality and judicial structures is different from one that prosecutes individuals. Constitutional judges, for example, are trained to plead differently from criminal jurisprudence lawyers. So even though you need a new constitution, even though you need new structures, you are going to be burdening the judges who will be trialing such former leaders and high-ranking officials on our side. So first, that's just not true. Second, it's still much better than the ICC. Given that we're talking about former leaders and high-ranking officials here, that's dozens, if not hundreds of people. Compare this, local courts with the ability to devolve trials to regional courts and up the chain of court command, or the ICC, a monolithic structure that I've already shown can barely handle 40 investigations in 12 years, let alone 100 in 6 months. We've already shown you why the ICC is not suited for the kind of task you're levying on them. Third response, we would rather the $12 billion sunk into the ICC in the past 12 years to be invested into local judiciaries. So you create precedent for domestic justice. So domestic courts can be strengthened in the future, so nations will continually outsource justice to the ICC. My second speaker's argument argument never rebutted by their team. Fourth response, we argue that courts like TRCs and the toolkit of local alternatives can work perfectly well. I point you to the Cha-Cha court after the Rwandan genocide, where the ICC couldn't possibly prosecute everybody involved in the genocide. Therefore, they defaulted to local-based courts, which are so much more effective in ensuring justice was done. No thank you. Last thing we heard under justice, ICC is impartial, thus good. One, this is not how they are perceived. The ICC is based in the Netherlands. The Assembly of States parties are dominated by Western powers like France and the UK. It's funded primarily by the EU, no thank you. Even if you insist that the ICC is impartial on paper, that's not how it's perceived. We say that African states have already condemned the ICC for being an imperialist construct. Is this disingenuous to suggest that African countries support the ICC just because they have signed the Rome Statute? You have to judge them by their actions and not by their words. No thank you. I point out the glaring contradiction that underlines the whole of their case. If you argue that African countries support the ICC, then how dare you say that African countries refuse to extradite people who are prosecuted by it? No sense at all. No thank you. Last thing we heard, international judges with expertise. We argue this is a substitute for analysis. We pointed out the horse trading that happens, the backroom deals that occur. I will vote in your judge in exchange for developmental aid into my country. Where does the list that the third citizen come from? It comes from these procedures, these problems with the kind of electoral systems of the ICC that causes judges not to be fully impartial and fully expert. Finally, we argue, what does impartiality even mean? It means you are divorced and insulated from local nuances and context. It means you are incapable of understanding, for instance, that if a general says, right, in order to attack that village, did he really commit a genocide based on the actions and the local circumstances of that particular country? We argue that delays process even more. I'm going to move on to my next key point, that of closure. Now, we argue that the point about how the ICC avoids guilt by association is bunk, because the best case scenario is that they only trial former dictators. Tell you what, okay, there are lots of former officials who go free on their side. This is bad for closure, because the man who used my baby as a human shield against the West is now going to be going free because you want to avoid guilt by association. That's the kind of closure that they want. But before I go on,
It's not what we're talking about that India just go. What we're talking about is former rulers and high-ranking officials. And that's what we're going to prosecute with the ICC.
my point being that such rulers and high-ranking officials often need to be prosecuted by local courts because they can best understand these nuances. They can best avoid the kinds of problems of your guilt by association. Furthermore, we argue that it's because the ICC takes years because of my previous analysis that we deny victims closure on their team. But you have to wait 30 to 40 years for the man who oppressed you, for the man who said that you weren't worth even existing in this country to be prosecuted. When the dictators you are trialing die before a verdict can be reached, that is not closure. That is a sham of justice. Finally, we argue that they provide no witness protection. Don't let them lie to you. Because the same structures that protect witnesses from the ICC rely on local alternatives to protect witnesses. That's how the ICC is structured. So they aren't any better for witnesses coming forward. Now, my last point is on post-reconciliation and construction. Now, we argue this us versus them mentality only contributes to more strife in bringing the ICC because it superimposes geopolitical conflicts on top of pre-existing ones. The problem is with the trial, the process of assigning blame, not the local nature of it. Because at the point of you assigning blame to one party, there will always be other parties wanting to refute the decision. Furthermore, they didn't deal with my second speaker's argument that is worsens conflict because often such apparent strife are underlined by colonial Western influence in the past. They further exacerbate such differences in ethnic and religious divides, and that's not what we want in a post-conflict society. Furthermore, we think it's bad if you redirect the anger toward the ICC because their entire policy hinges on people liking the ICC and respecting its decisions. They don't stand for justice. It is where justice ends and politics begins, and I am incredibly proud to oppose.
sloppy than ever. So what we see is that we'd rather take a lot of time, invest money, and have no one in the end achieve justice at all. And what we see is that opposition coming to you today in their first speech agreeing to the principle that the international community has to do something, but then bringing you to the alternatives that the local courts are in charge, that the local courts have to do it themselves, and we can't infringe upon their sovereignty. Where we see the two main clashes is the local failure, and second of all, why the ICC is actually the right path. So let's walk you through this step by step. First of all, the local failure. Ellie's speech brought to you the ideas that in the local post-revolutionary state, they are not the best suitable people to actually deal with things like genocide, crimes against humanity, and so on. We saw side opposition so idealistic coming here to you saying, well, they'd love to do it, and they aren't going to be biased towards anyone because where would their incentive be? What we said is we point you to history, that in every revolution we actually see that because there are so many emotions involved, that you are never going to think rationally. That no party that actually overthrew the government actually has a hatred towards them, which led them to actually being violent. Will actually in the end just say, well, yeah, we're going to be fair with you. They are actually going to be very biased, and we pointed that out down the bench. Now we would like to just wake up that opposition out of their dream world. But then they brought to us these alternatives of what the locals could do, right? And they expanded, first of all, the idea of truth and reconciliation committees, but then dropped it and then brought it up in again, not really being sure. Because our third speaker actually brought really good analysis on showing you that what actually happens is that you give them immunity, a response never addressed by side opposition. That in order to get for these truth and reconciliation committees to work, you have to have immunity. And this actually contradicts the whole principle of giving them closure and bringing them to justice. And like the only resort they had was when everything failed was to point us out on the fact that we didn't address their sentence with these opposition arguments. This was that the ICC will bring more division in their country, which actually goes directly against my argument of saying that, well, by giving it to local courts, we actually create more anger. And by giving it to the ICC, we redirect the anger, saying that we actually eliminate the division and the further conflict by taking it away. So, but where the question, where the debate, in the end, at the end of the day really comes down to is the ICC the right actor, and can they do it? They had three answers to this. It is inefficient, it is expensive, and it is biased towards Africa and unfair. So, we have several responses, and we brought to you these today. We said it is not inefficient, because what we see is a response never tackled by said opposition, that it's only been 10 years. We brought you the analogy that the United Nations, after 10 years, only had 60 member states. The UN implemented for a push towards peace, having far greater significance than the ICC. Never responded towards that. We said that 10 years is a very short period of time when we're actually moving toward a greater solution. Second of all, we responded that in light of what we are dealing with, it is not expensive. And it would be far more expensive to set up local courts in every single post-revolutionary state, because every single post-revolutionary state dealing with such a trial would have to adequately represent the abilities that the ICC has, which are already in place. So say we already spent the money, but we can actually use that in the future, not having to reinvest every single time. And in the end, they always came down to saying that we were Western biased, that we actually contradicted ourselves on the whole Africa issue. But what they missed was our analysis that I brought to you in our second speech, saying that Africa, in fact, is the biggest regional bloc represented in the ICC with 13 countries. That is not all African countries. So when some of the leaders go to some of the minority cases in Africa, then it is not the fault of the ICC that we cannot extradite. Not saying that Africa itself is actually supporting the ICC. And it's for these reasons that we today have won the debate on side proposition. Thank you.